In my DUI practice, one of the very first questions I ask a potential client is whether they refuse to take the breath test following their arrest for drunk driving. And that's because, like most states, Michigan has an implied consent law that requires motorists to take a chemical test at the request of a police officer when they're arrested for suspected drunk driving or a related offense. Now, in most cases, the officer requests that the person arrested submit to a breath test on a testing device that's called a DataMaster. And the purpose of that test is to determine whether the alcohol concentration in a person's breath is above the legal limit, which in Michigan is 0.08. Now, a person who refuses an officer's request to take the test typically has his or her operator's license confiscated and is issued a temporary driving permit. The permit contains an express notice that the test was refused and that the person who refused the test has 14 days from the date of the arrest to request a hearing to appeal the refusal. Now, importantly, failure to request an appeal within the 14 days results in a 1-year suspension of the person's driver's license, and a second or subsequent refusal within 7 years results in a 2-year suspension. But the important point is this: if you were arrested and refused the breath test, make sure that you file your request for a hearing within 14 days of the arrest date. Then, seek the counsel of an experienced DUI defense attorney who can guide you through the complexities of the appeal process.